Okay, so we talked about the creation of the agency relationship. We also talked about the termination of it. Now we'll think through some of the consequences of an agency relationship. When two persons have created an agency relationship, there are special powers and liabilities that come with it. Most notably, we'll make the principal liable for the agent's actions. We'll also impose fiduciary duties on the agent. We'll talk about that later. In this video, we're going to talk about liability in contract. Our basic question is, when is the principal liable to a third party? So let's use a simple hypothetical. Ajit and Paula have entered into an agency relationship. Ajit agrees to buy a helicopter for $70,000 on Paula's behalf. Our question is Paula bound by the contract that Ajit signed on Paula's behalf? Here we have Paula as our principal and Ajit as our agent. Ajit executes a contract on behalf of Paula. The question is Paula bound to make good on that contract? There are a variety of ways that an agent will be empowered to bind a principal. We're going to talk through all of them. All we need is one of these. We either need Ajit to be acting with actual authority, apparent authority, inherent authority. We need to have grounds for estoppel or ratification. We'll talk about what all these mean. But if we want to say that Paula is bound in contract by the acts of the agent, Ajit, then we need to have one of these 5 grounds for liability. We can have more, that's fine, but we need to have at least one. So let's start with actual authority. This is from the 3rd restatement. An agent acts with actual authority when, at the time of taking action that has legal consequences for the principal, the agent reasonably believes, in accordance with the principal's manifestations to the agent, that the principal wishes the agent so to act. So what matters here is, what does the principal say or manifest to the agent? An agent who acts in accordance with that manifestation binds the principal. The manifestation, the message from the principal to the agent, could be oral, could be written, or could be implied. Let's take a look at this example. P goes to an office where, as he knows, several brokers have desks, and leaves upon the desk of A, thinking it to be the desk of X, a note signed by P, which states, I authorize you to contract in my name for the purchase of 100 shares of Western Union stock at today's market. Unaware of the mistake, A comes to work, finds the note, and makes a contract with T in P's name for the purchase of the shares. A has actual authority to make the contract, and P is bound by A's action. Why? Why does the agent have actual authority here? Well, that's because the agent reasonably believes that the principal wishes the agent to do it. The touchstone when we're asking whether the agent has actual authority is the manifestations the principal has made to the agent. Here, even though this isn't what the principal meant to do, the principal has made manifestations to this agent. A related concept I just want to flag here is incidental authority. The idea here is that the agent has authority to do what's necessary, usual, and proper to accomplish or perform the express responsibilities of the agent. So I say, go buy a couch for me, but I don't give you money. You have actual authority to go buy a couch for me. You have incidental authority to use my credit. in order to buy the couch. I said buy the couch. I didn't give you any money. You have to have a way to do it. And so you can use my credit. Our second doctrine here is apparent authority. Apparent authority is a different route to making the principal liable for the contract of the agent. Here's the language from the third restatement. Apparent authority is the power held by an agent or other actor to affect a principal's legal relationship with third parties when a third party reasonably believes that the actor has authority to act on behalf of the principal, and that belief is traceable to the principal's manifestations. What's different about apparent authority from actual authority? With apparent authority, the principal has done something to lead a third party to believe that some actor is authorized to act on the principal's behalf. When that's happened, then the agent has apparent authority. So we're looking for two different sort of routes of a message here. With actual authority, what we looked at before, we care about the principal's manifestations to the agent. With apparent authority, we care about the principal's manifestations to a third party. Let's look at an example. P gives A, an agent who is authorized to sell a piece of property on behalf of P, specific instructions as to various terms of the sale, including the minimum price P is willing to accept. P informs possible buyers, third parties, that A is his selling agent, but obviously doesn't communicate a specific instruction to anyone but A. Doing so would let the buyers know how cheaply they could buy the property. It's natural that A is and P are not going to share that information. A has actual authority to enter into a contract to sell the property only at a price equal to or higher than $300,000. That's because we're talking about actual authority. The question is, what manifestations has the principal made to the agent? That's why the $300,000 matters. But what about apparent authority? A has apparent authority to sell the property at any price, given that the principal made representations to third parties that A is the agent. That's because, again, apparent authority, the principal has created the impression with third parties that the agent has authority to sell the property. Again, the scope of actual and apparent authority both depend on what the principal says, but the audience varies. For actual authority, what matters are the manifestations the principal has made to the agent. For apparent authority, what matters are the manifestations the principal makes to a third party. Another thing to note here about apparent authority is that, at least under the third restatement, it's sufficient to bind the principal even when there's no agency relationship in the first place. Also, an agent can never create apparent authority. Only the principal can do that. And so if we're talking about apparent authority, the manifestations of the agent don't matter. Only the manifestations of the principal matter. A principal could create apparent authority by giving someone a title or a position. Both actual authority and apparent authority are at issue in the case of White versus Thomas, which you'll read. I want to talk about inherent agency power. This is a tricky concept created in the second restatement, and it involves an agent's power deriving not from anything we've talked about so far, actual authority, apparent authority, but instead solely from the agency relationship, and exists for the protection of persons harmed by or dealing with a servant or agent. So to really understand that, we need to bring in this distinction on the slide here about different types of principles. 3 different types of principles: disclosed, partially disclosed, or undisclosed. The disclosed principle is obvious. An agent goes in and says, I'm acting for somebody else. And the identity of that person is A, P. Partially disclosed principal is where the agent says, I'm acting for somebody else, but doesn't identify the principal. And an undisclosed principal is where, at the time of the transaction, the third party has no idea that the agent might be acting for somebody else. The third party thinks the agent is acting on the agent's behalf. The agent hasn't said, hey, there's a principal I'm acting for. I'm not here on my own behalf. The idea behind inherent agency power is that for a general agent, someone who's engaged in a series of transactions for a principal, the agent can bind the principal even if the agent was expressly forbidden from doing a particular thing, if the other party reasonably believed that the agent was authorized and had no notice that there was no authority. Let's look at an example. This example comes from a famous case, which we're not reading. P employs A to manage his cigar bar, directing A to represent that he, A, the agent, is the owner, and to purchase no goods for the business except alcohol and bottled water, with all other goods to be supplied by P. A purchases cigars from a third party, T, for the business. P is subject to liability to that third party for the cigars. Why? Well, because the agent has inherent agency power. The third restatement says that it takes a different approach, but it's possible to end up in basically the same place. We'll explore this more when we talk about the Gallant insurance case. But the rationale for holding the principal liable here in this example is that it would be unfair to allow principals to use agents without holding them responsible for the acts they do out in the world, the harm they commit. We have two remaining ways of holding a principal liable for an agent's contracts: estoppel and ratification. These two are addressed pretty quickly in the book, but I want to draw out what's going on with them so we don't leave any loose ends. Here's the idea with estoppel. This, if you're familiar with estoppel, in other legal situations, it's the same basic idea, but here from the third restatement. The doctrine is applicable when the person against whom estoppel is asserted has made no manifestation that an actor has authority as an agent, but is responsible for the third party's belief that an actor is an agent, and the third party has justifiably been induced by that belief to undergo a detrimental change in position. Most often, the person estopped will be responsible for the third party's erroneous belief as the consequence of a failure to use reasonable care, either to prevent circumstances that foreseeably led to the belief or to correct the belief once on notice of it. I'll give you an example. P has two co-agents, A and B. P has noticed that B, acting without actual or apparent authority, has represented to a third party, T, that A has authority to enter into a transaction that's contrary to P instructions. A is going out there saying A can do things that P said A can't do. T does not know that P's instructions forbid A from engaging in the transaction. T cannot establish conduct by P on the basis of which T could reasonably believe that A has the requisite authority. T can, however, establish that P had notice of B's representation and that it would be easy for P to have informed T of the limits on the authority. In other words, we don't have actual authority, actual authority, apparent authority, even inherent authority, but what we do have is the principal being aware of the representations the agent made to the third party that were wrong and not correcting them. And a third party here detrimentally changes position, relying on that representation, in this context, making a down payment. And P would be estopped from arguing that the agent did not have authority. Note in estoppel, the third party, again, generally can't make apparent authority because the principal hasn't made any manifestation to the third party. And another distinction, at least between estoppel and apparent authority, with estoppel, the third party has to detrimentally rely on the belief, and there's no requirement like that for apparent authority. It's all about the manifestations made to the third party. The final way a principal can be liable to a third party is through ratification. Even where the agent has no authority, a principal can ratify the transaction. This happens after the fact, and that will bind the principal. Ratification can be express. I hereby ratify the contract purportedly entered into on my behalf, or it can be implied. It would be implied if the principal engages in conduct that can be justified only if the principal is treating the agent's acts as authorized. So the big one here is accepting the benefits of the transaction. Here's an example. P owns an advertising agency and employs A to service existing accounts by purchasing space in advertising media. A does not have authority to set terms with clients. A, nevertheless, executes an agreement with a third party that commits P to develop a new advertising campaign for that third party. The principal learns of the agreement and then accepts and retains advance payments made by the third party for the new advertising campaign. Here we have ratification. It's not express, but it's implied. When the principal accepts and retains the payment, the principal has impliedly ratified the contract that the agent entered into on the principal's behalf. Okay, there we are. That's our tour of the ways that a principal can be liable in contract to a third party.